Okay, and so coming up next, we're going to talk a little bit about, talking about privacy and AI governance. Our speaker will be Eleni Kyriakidis. She is an adjunct professor at Georgetown Law School and a practicing attorney specializing in AI law in Washington, D.C. She is also the co-author of the AI Policy Sourcebook, which is also coming from the Center for AI and Digital Policy. Eleni.
Good afternoon, everyone. Thanks so much for the introduction, and to the University of Minnesota DSI for having me. I'm going to be talking to you about AI, privacy, and data protection. There's many tensions and unanswered questions about how privacy and data protection principles should be applied to AI, especially frontier models and generative AI. So today, I'll highlight for you some of those tensions and some recent developments that are helping us to get better answers around how AI and privacy can coexist. Here I have pictured the evolution of the privacy attorney. So I find most attorneys working on AI started as privacy attorneys, but now we are all called to become AI attorneys. I'm pretty sure I'm somewhere in the middle of this evolution still. Why is this? Privacy attorneys are used to navigating some of these complex cross-jurisdictional issues, emerging technologies, and issues of individual rights and ethical considerations. So here we are evolving and learning together. First, I want to take a moment to situate where privacy law fits into the larger picture of the law of AI. I think about the law of AI as having two primary buckets. There's the first new emerging category of AI laws that are far fewer and that expressly target the navigation of AI. For example, the California AI Transparency Act, enacted in 2024. So this requires companies to disclose when consumers are interacting with AI systems, or of course the EU AI Act, the most well-known comprehensive AI law adopted in 2024, more in effect a product liability law. There's also comprehensive laws now in Japan and Korea. Then we have this whole other bucket of generally applicable laws that predated the AI revolution. I find especially some early stage companies, startups, that think that AI is wholly unregulated because we don't have a federal law. And this is just not the case at all. These pre-existing laws still apply even though you're doing AI. There's no exception for AI. A good example of this is the FTC's Operation AI Comply, announced last year. So under the FTC Act Section 5, they have the ability to go after companies engaged in deceptive or unfair practices. So they filed a number of complaints against AI companies making false claims about how they use AI and their AI capabilities. Another category of this is copyright law. So many companies like OpenAI and Meta have faced legal challenges alleging that they're scraping and using copyrighted material for AI training without the appropriate permissions. And then we have privacy and data protection law. Of course, an enormous category of this pre-existing neutrally applicable law that has huge implications for AI. So that is what we are talking about today. Part of the reason is this map. This map shows countries with comprehensive or substantial sectoral data protection legislation. And as you can see, this covers most of the world now. So grappling with the data protection implications of AI is critical and unavoidable. While there's some overlaps in AI ethics and data protection, some AI ethics principles appear in data protection law. They remain distinct fields with privacy and data protection focused on control and fairness in processing of your personal data, and AI law targeted usually more in that product liability direction I mentioned. When is data protection law going to be triggered? Whenever there's processing of personal data, and this can be quite a broad term. So oftentimes, depending on the law, it's use, transmission, collection, recording, storage, structuring, anything you do with personal data. And so for AI, it could mean when personal data is used to train or test that model, or when the model is deployed and personal data is used to make decisions about individuals. So if you use AI to process personal data, you need to comply with the principles of data protection by design and default. However, unfortunately, there's not a lot of clarity about how data protection law applies to the use of AI. Great for the legal business, hopefully great for job security for me. However, the ambiguity is a big problem for any company that wants to do the right thing and comply with the law. So I'm going to highlight some of those key questions and tensions, and after leaving you with a lot of questions, I'll show you a few of those areas where we are getting concrete regulator guidance and more case law that help to answer the open questions about the application of privacy to AI. I'm going to look at this primarily through the lens of EU data protection law, the GDPR, because it is the dominant model of data protection law. It's been adopted in many jurisdictions around the world and is based in many of the principles that appear here in the United States. It's also shared by a lot of the state laws in the United States. While there's some differences in approach, what I'll be talking about today certainly mirrors many of the issues being answered in every country by every company and every regulator around the world. One of the most significant tensions between AI development and privacy law lies in the principle of data minimization. This is a core tenet of frameworks like the GDPR. It requires organizations collect, process, and retain only the personal data that is necessary for a specified, clearly defined purpose. So this is oftentimes at odds with how AI systems are built. While data minimization demands restraint, AI development oftentimes depends on having more data, not less, including information that may not seem necessary at the time of collection. AI systems thrive on these large, diverse data sets. More data can improve accuracy, enhance robustness, reduce bias. AI models frequently require long-term data retention for things like model updates, retraining, auditing, and explainability. Yet, data minimization imposes limits on processing personal data just because it might be useful at some point in the future. So this creates a persistent legal and operational challenge for those developing AI. What can we do to resolve a tension like this? Simply put, the default approach can't be collecting and using as much data as possible. You need to think about ways to achieve the same purposes with less data, doing your best to eliminate data points that are clearly not relevant and to justify what you do keep. The key is not that you collect no personal data, but only that you process the data you need for your specific purpose, which is going to be case specific. And legally, you do need to balance minimization against other values that are legally required, like accuracy. There's also a range of privacy-enhancing techniques now you can use to minimize the personal data being processed at the training phase, like adding noise, relying on synthetic data, or federated learning. Very analogously, the principle of purpose limitation requires personal data be collected for specific, explicit, and legitimate purposes, and not processed further in a way that's incompatible with those purposes. In other words, you can't collect data for one reason and then later develop an entirely different purpose for it without a proper legal justification. So this is also particularly challenging for AI development, where future use cases are oftentimes uncertain. AI models are frequently repurposed or fine-tuned after their initial training, making it difficult to define a narrow and fixed purpose for data collection upfront, especially since AI's value often lies in discovering unforeseen patterns or applications. This also creates, I think, a strong temptation for companies with large data holdings already to retrofit existing data for AI purposes. For example, though, if a user shared their data for improving customer service, you can't then use that to train a predictive model according to the purpose limitation principle. While frameworks oftentimes allow for a compatible secondary purpose, this sort of compatibility test is quite complex, fact-specific, and therefore legally uncertain, leaving organizations with limited clarity about whether their purpose is legally permissible. The principle of security. This requires personal data be processed in a manner that ensures appropriate protection against unauthorized or unlawful processing, as well as loss, destruction, or damage. So in the AI context, also quite challenging. Ensuring robust security in AI can be hard for a few different reasons, including reliance on third-party code or external suppliers, which can introduce vulnerabilities if you have limited insight into their security practices. And even if personal data is not stored in raw form in the AI model, AI models can still inadvertently reveal such data through their outputs. There's risks from users themselves. So whether there's malicious attacks or unintended prompts, users can cause the model to leak or reproduce personal data that was used as a part of the training set, posing security and privacy issues. So I'll give you two examples of different kinds of attacks. One is a model inversion attack, where if attackers have some personal data on an individual in the training data, they can attain more data about that individual by observing the model inputs and outputs. A second type of attack is a membership inference attack, where a malicious attacker deduces whether a given individual was present in the training of a model by probing it. So you can imagine, in a lot of cases, not that important. In some cases, if the model is trained on a vulnerable or sensitive population, such as some sort of health model, maybe they had an underlying health condition they're testing for, this could then become quite a significant risk. Another challenge, data subject rights. So data subject rights under the GDPR, but also under a lot of other frameworks, include the right of access, the right to request corrections to your personal data, the right to request deletion, also called the right to be forgotten. And these rights apply at all stages of AI system development and deployment, wherever personal data is involved. So ensuring these rights in the context of AI, also quite challenging. So in the training phase, AI models are often built on these large unstructured data sets from diverse sources. They're rarely tagged with clear links to individual data subjects. They're often not stored in retrievable or structured formats. In some cases, developers may not even know whether there's personal data in that data set. Say it was scraped from across the web, you may not know that there's personal data in there. Still, individuals retain these rights to access, correct, and delete their personal data. Although less common, if raw personal data is stored in an accessible format in the model, controllers, businesses, remain obligated to fulfill rights such as access, rectification, and erasure. So imagine in the case of rectification or erasure, addressing a single individual's data in that model may require retraining the entire model, which could be complex and tremendously costly. But generally, data protection obligations don't permit exceptions for difficulty or expense. Okay, so as promised, so far I presented a lot of problems without really great answers, but also there are some core areas where we are getting recent developments, actual case law, strong regulator guidance that is giving us some guideposts with how to comply with privacy law when it comes to AI. These areas are the transparency that's required for automated decisions about individuals, the legal basis required for training AI models. So anytime you process personal data, you need a legal justification. In a lot of data protection frameworks, that's called a legal basis. Then finally, how to anonymize AI models. If you don't have personal data in your AI model, you don't have to worry about compliance with these data protection frameworks. But when is a model truly anonymous? First, to rights related to automated decision-making. GDPR Article 22, you can also find similar rights in US laws, provides individuals a right not to be subject to decisions based on solely automated processing with legal or similarly significant effects. So this is a general prohibition on these types of automated decisions. A legal or similarly significant effect, what is that? That's going to be something that impinges on your legal rights or status or something of similar significance. So think of decisions around government benefits or a visa or a job, your admissions to college, things of that sort. To be covered by this prohibition, it also has to be a solely automated decision, so a decision taken without meaningful human intervention. There are 3 exemptions, also up on screen, where you can make these solely automated decisions, where it's necessary for entering into the performance of a contract, where it's authorized by law or based on explicit consent, which is quite a high bar. Even if you're allowed to rely on the exemptions to conduct solely automated decision-making, you still need to introduce additional safeguards, simple ways for an individual to request human intervention, to express their view, and to challenge a decision. There's also transparency rights around automated decision-making. So individuals have to be provided information about the existence of automated decision-making and meaningful information about the logic involved, as well as the significance and envisaged consequences of such processing for the individual. So what does all of this mean in practice? The ICO, the UK Data Protection Authority, and the Alan Turing Institute, they've co-developed some really excellent, really detailed guidance on explainability that I highly recommend. You can easily find this guidance by searching the web. They detail 6 different kinds of possible explanations you could provide regarding AI, depending on the context of the decision and your audience. So you could combine these different kinds of explanations in various ways to suit your circumstances. And all of this needs to be delivered in an accessible and non-technical way. So here are the 6 types, briefly. A rationale explanation, the reasons that led to a decision. Responsibility explanation, so who is involved in the development, management, and implementation, and who to contact for human review of a decision. Data explanation, what data has been used in a particular decision and how. Fairness explanation, the steps taken to ensure the decisions are generally unbiased and fair. Safety and performance explanation, steps taken to maximize the accuracy, reliability, and security and robustness of decisions and its behaviors. Impact explanation, so steps taken to consider and monitor the impacts on an individual or on wider society. In addition to some good guidance, we do have some case law in this area. So there's been 2 really significant cases on automated decision-making from the Court of Justice for the EU. This is the highest court in the EU. The first I'm going to talk about is Schufa, which was decided in 2023. In this case, a German credit agency provided credit scores to a financial institution that then later used those to make loan and mortgage decisions. The question here was whether what Schufa was doing was an automated decision covered by this prohibition, or was the creation of a credit score a mere preparatory step for the banks that make that decision. The court found that Schufa's generation of the credit score was one of these automated decisions because the bank drew so strongly on the credit score to make its final decision. Also, the court found, interestingly, that it was a solely automated decision, even though there was a human in the loop at the bank. So what the court said here was the quality of the human intervention matters. Here, the output of that score was largely determinative, with the human acting as a kind of rubber stamp. So we get some actual weight to this right of human intervention here, and the scope of Article 22 broadens as well, sweeping in credit agencies and those making preparatory steps toward an automated decision. The second case I'll talk about, also a Court of Justice case from this year, is Dun & Bradstreet. Here, the court ruled on the right to transparency related to automated decisions under Article 22. The court said that the right to explanation to a decision, it has to describe the procedures and the principles actually applied in such a way the data subject can understand which personal data have been used and how in the automated decision making. So again, this beefs up and clarifies what we're talking about legally when we're talking about a right to explanation for an automated decision. On to the second area where we're getting some interesting and valuable recent developments. This is around the legal basis to support AI training. So in short, in a lot of data protection law, and for the GDPR specifically in Article 6, you need legal justifications to collect, use, and otherwise process personal data. These bases are on screen. They include consent, performance of contract, compliance with a legal obligation, protection of life and limb, that's vital interest, performance of a public task, and legitimate interest, which requires that the processing be necessary to pursue the valid interests of the company, the organization, were not outweighed by the individual's rights and freedoms. So most of these are not obviously compatible with the need to collect data at a large scale for AI training. Consent, typically impractical, since AI training often involves these large unstructured data sets. There's not obviously a way to contact individuals or to inform them necessarily. Also, the more things you want to do with data, the harder it is to ensure that the consent is valid because it needs to be specific and informed. Performance of contract only applies in really narrow circumstances, so where the processing using AI is objectively necessary to deliver that service. And this won't usually be available because usually you can exclude a single individual's data from an AI model and it can still be trained successfully. Legal obligation, public task, vital interest, also almost never available unless you're facing a specific legal requirement like AI auditing, you are a public authority, or for vital interests, you could think of it for something like an emergency medical diagnosis you can't get consent for. So that leaves us with legitimate interest, which is the legal basis that is most flexible and that all companies want to invoke for AI training. However, relying upon this entails significant risks. As I mentioned, there's a balancing test here between the organization's interests and the individual's rights and freedoms. This test is interpreted restrictively, and large-scale data collection, invasive profiling, or automated decision-making, these things can tilt the balance against the organization. So authorities are more likely to object to this basis if you're violating an individual's reasonable expectations or harming them in some way. We do have some good guidance here, released recently from the EDPB. This is the EU's top authority for interpreting the GDPR. And they've just issued some significant guidance on the use of AI models, including the reliance on legitimate interest as a legal basis for AI development and deployment. Really importantly here, the EDPB did not rule out the possibility that you can rely on legitimate interests for AI training based on scraped data from public websites. So this is a more permissive outcome than some would have thought from the privacy regulators. However, of course, they set a high bar for engaging in this activity, which can still present some significant challenges for those building AI. So the guidance outlines a three-part test for legitimate interest. The purpose test: is there a legitimate interest pursued by the controller? Necessity: is the processing necessary to achieve that interest? And the balancing test: are the controller's interests not overridden by the rights and interests of the data subject? Key considerations here, the EDPB stresses, again, those reasonable expectations of the individual. So factors to consider include, was the data publicly accessible? The nature of the relationship between the individual and the entity collecting that data. Did they have a relationship or did they have no relationship? The context and the source of the collection. Were there privacy settings on for the website they were collecting the data on? Was transparency provided about this data collection? Were individuals even aware that this personal data was online? You can think about this in the context of purchasing information from a data broker. The guidance also recommends some mitigation measures such as data masking, input and output filtering. All of these can help strengthen the balancing test in your favor. Yet in practice, my sense is from developers, a lot of these techniques are still very hard to apply. Ultimately, this remains a case-by-case analysis. So inevitably, that creates a degree of legal uncertainty. We don't have cases where we know it's okay and legally permissible to go forward and do this activity. It's not okay to do this. It's a case-by-case analysis. Here is the proof that issues around legal basis for AI is risky. So most recently, Meta announced that it would start training its AI on posts and photos and comments of Facebook and IG users in the EU. And they limited that announcement to public content from users over 18. They provided an opportunity to opt out, but they have received a good deal of pushback, especially from civil society. Up here, that's an announcement from a famous group, Noib, that's arguing for opt-in consent for that activity. OpenAI was also fined 15 million euros by the Italian DPA, and they were actually blocked temporarily in Italy. They alleged that they had no lawful basis for their AI processing. We also have the example of the bevy of fines against Clearview AI. So they face substantial fines and orders to delete data from a lot of different regulators in Europe. There's also, of course, been lawsuits against them here in the US. They scrape facial images online without the knowledge or consent of individuals. Then they sell those databases to law enforcement around the world. So enforcement actions, again, push back on their use of legitimate interest as a legal basis, saying essentially the processing was far broader than anybody would have expected, and it was far more than was strictly necessary because there would be no law enforcement interest in a whole host of people included in that database. Finally, I'll touch on some recent developments around anonymity. So when AI models are anonymous, they fall outside of the scope of data protection law. That's going to reduce your regulatory burden substantially, avoiding those substantial fines that can come along with data protection law. The GDPR says anonymous information does not relate to an identified or identifiable natural person. This is different than pseudonymization, which is simply a privacy-enhancing tool. It is technically reversible. Anonymization generally means that no re-identification is possible. The problem is it's not clear whether anyone actually knows what anonymization means in practice. So many studies have shown it is practically impossible to perfectly anonymize data, meaning that some possibility of re-identification always remains. Some regulators will accept just stringently limiting the risk of minimization of re-identification, while others take a much more absolutist view that data should not be able to be re-identified at all. As I touched on earlier, there's risks that prompting these models trained on personal data can result in the inappropriate disclosure of personal information, or that personal data can be extracted from the model itself. This makes anonymization particularly hard. So I have one study up on the screen which showed an adversary can extract gigabytes of training data from open source language models and closed models like ChatGPT. So this is recovering a lot more data than they previously thought from these models, a significant privacy challenge. So what can we do to get some clarity around these challenges in anonymization? The new EDPB guidance on AI models also discusses anonymization of AI models in addition to those issues around legitimate interest. like legitimate interest, the EDPB doesn't rule out the possibility that models trained on personal data can be anonymous, but they, again, set a high bar. It stresses the need for these case-by-case assessments based on the likelihood of personal data being extracted directly through the model or from the model's outputs. So in order to claim your model is anonymous, it should be very unlikely to directly or indirectly identify individuals. A couple of important takeaways from the recommendations. First, documentation. The EDPB notes that providers who want to make claims about anonymization, they need to have substantial documentation to support that position, including documenting the specific measures taken at each stage of the model lifecycle to reduce re-identification. So document, document, document. Second, the EDPB notes anonymization should be considered in light of all the means reasonably likely to be used to extract personal data. So what is the state-of-the-art technology for attackers, for example? But also importantly, this piece leaves open the possibility that there can be some measure, some risk of re-identification, and still it can be called anonymous. There's also a higher risk tolerance for internal models versus external and publicly accessible models, which I think is a fairly sensible position. All right, I've talked about many of the key tensions and questions related to privacy and data protection in AI, but do not get me wrong, there are many, many more that we have not covered here. I have to plug the recently released book from myself and the Center for AI and Digital Policy before I end. You heard about their excellent report in the presentation before me. This source book is a reference book for global legal and policy frameworks on AI around the world, all different jurisdictions. So if you're interested in what I talked about here today, please go check it out on Kindle and in print on Amazon. And with that, thank you so much for your attention. I hope you found this session useful. If you want to get in touch with me, this is my email up on screen. Feel free to drop me a note if you have further questions or you just want to connect. With that, shall I open it up to questions?
Thank you. Great talk. Just two framing questions. One, a lot of analysis on the GDPR. So when you look at healthcare and HIPAA, the law says we're supposed to forget, GDPR says we're supposed to forget the patient, but by our regulations, we have to retain records. So one, just maybe comment on that intra-country perspective. And second, where does GDPR stand on a deceased person?
Deceased people do not have rights under the GDPR, but there are some member states that grant rights to deceased people. It's interesting that you mention this tension in documentation because it actually does come up in the data protection context too. So there's a tension, for example, between things like minimization and deletion obligations while still needing to fulfill data protection rights, like retrieving that data, that original training data, right? So those tensions are things in data protection law too, with not a perfect resolution.
Question, so an AI company creates like this, or they get a bunch of information, which is this large language model, and they train it, and then people prompt that AI. Is the information that we're trying to keep private, is that just from collecting the large language model, or if you enter data inappropriately through a prompt, does that become part of the model?
So mostly what we're concerned about in that case is the adherence of data protection law. So it's perfectly fine, actually, if it's sharing personal data in those prompts, if that is what was intended. But if it's not what was intended, that's what we're concerned about.
Okay. So,
for example, we asked ChatGPT about questions about famous people all the time, and it responds. That's an intended response. But data protection law would adhere to ChatGPT. If we're trying to have an anonymous model, we don't want it sharing personal data, then that would become a problem. And then you would fall within the ambit of data protection law when you didn't intend to. I hope that's helpful.
Okay.
Thank you very much for your talk. You covered a lot, and I just commend you for bringing us through that in a way that was really engaging. My question really revolves around the Schufa case in Germany. I think that has tremendous sort of philosophical implications, especially around, obviously, the key issue, automated decision-making. I wonder to what extent it's been pondered in law. Maybe there are sort of peripheral cases where, for example, AI has had tremendous influence at various stages in decision-making. Coming off of the AI in healthcare in particular, you might see, the AI pointing at an area of a colonoscopy image and saying there, and the physician just making a decision based on that. I mean, that's kind of an obvious case, but there could be other things where, for example, someone's decision on financial matters or otherwise are heavily influenced by AI prior to the decision, and how that sort of factors in. Is there thought, is there writing about this? Because it's going to become increasingly important to understand how we separate these things.
Yeah, I mean, I think the interesting problem that Schufa raises is there's probably all sorts of applications that preceded actually like the AI revolution that we were never really thinking about and may not have intended to sweep into this landscape. Also, even newer technologies, when you think about something like fraud detection that's automated, having a lot of process and barriers around that might not actually be super beneficial or appropriate in that context. So there's a lot more work to be done. I don't think that we have a good answer yet. I think it's going to take a lot more time, a lot more cases before it's worked out.
Thank you.
Thank you. That was fantastic. So I'd like to offer a hypothesis that I'd like you to maybe react to. So again, so I represent kind of mid-market and smaller startup clients. So my one view of data privacy law, as you've just described for us, and its application to AI, is that the largest companies like Google and Meta and so forth will just do whatever they feel like doing. And they'll pay the $15 million fine, or they will set their army of lawyers against the regulators, and they're just going to do what they're going to do, which might include crossing various lines. Whereas, so that regulation, even if well-intended, will tend to be crushing or stop, I'll call startups and mid-market companies, but favor incumbents who have enough bankroll to just violate and go forward. Any comment on that hypothesis?
I mean, it is certainly, I think there is some heft to it, some credence that we should give that argument. There are ways that data protection laws sometimes try to carve out responsibilities that can be reduced for small and medium-sized businesses. I think that we need to do more of that, certainly. But I think the flip side is, I don't always, in my professional experience, I haven't always seen that smaller companies are willing to be more compliant or adherent necessarily. And also, I think that larger companies can tend to face really significant reputational costs that can cut into business beyond the pure legal costs of failing to comply with data protection laws. So I do think that while the incentives may not be perfect, we're getting some good incentives there.
Thank you.
So GDPR is European. If a United States company does business in Europe, Meta, they have to be bound by GDPR. But what do US courts do with GDPR when it's entirely within the United States?
Nothing. However, many US companies are subject to the GDPR even though they don't have operations in Europe because of the territorial reach of the GDPR. If you're targeting Europe with your business, essentially, then you can be captured by the GDPR. However, as I mentioned, many of these principles, not in identical form, but a lot of these principles are appearing in whether it's the California privacy law and the regulations that are coming out of that. There's automated decision-making rules that are coming out of the new regulations, the Virginia privacy law. Many of these share the same principles, not identical, but also there's partnerships across the pond. And so California is really interested in working with Europe and learning from some of their interpretations. So I think that we can't just sort of cabin what I've said to Europe, certainly.
So in a courtroom, would a lawyer be able to argue GDPR in that courtroom if it were, say, in the state of Minnesota and doing business just in Minnesota?
They would not, but the way that it might come up is the privacy regulator in Minnesota might say, ooh, I really like what the EDPB is doing. I'm going to implant those ideas into some of my enforcement actions.
All right, thank you very much.
We have time for one or two more questions. So I'll go. Oh, sorry. Over there. There we go.
One other question, you went into quite a bit of depth on anonymization. So a variation is synthetic data generated from real data. And where does that fall on your spectrum of identifiable or not?
I mean, most of these, even the tests around what is personal data, are so super fact dependent. Oftentimes, it can depend on what other data is available to the individual that might do the re-identification. So it's unfortunately just impossible to say without knowing the context. However, my experience with most of these sorts of techniques is mostly that they get us to pseudonymization and not anonymization. So good, nice to have data minimization techniques, but doesn't get us all the way, usually.
Other questions? Okay, so I'll briefly ask then. So we've had stories about things like DeepSeek involved with adversarial training, right? So that they're essentially using another AI to train their AI. So is there like a poison by a poison chalice or something like that, right? Yeah, that it's so if I rely on a prior AI that was violating privacy rights, right, left and right, and I now rely on that to train my AI, does that then is there sort of like a down the path, or am I able to like sort of sidestep that by this?
So I'm struggling with the hypothetical a little bit. Is it that you are basically adopting the behaviors of that AI, or?
Yeah, so you would essentially reproduce what the other AI is, but without reusing any of their underlying training data, which would have been which gave rise to the privacy concern in the first place.
Well, I mean, I think we don't get around the problem of the attacks that I mentioned, because none of those necessarily rely on the training data being present. They rely on sort of memorization of the algorithm, so just replicate the same problems. Anything else?
Any other questions? Okay.
All right.
Yep, so thanks very much. Round of applause.
Thanks, everyone.